May it please the court, Petitioner Kevin Cockrum appears via Zoom and by interim counsel Alejandro Vasquez, also by Zoom.
May it please the court, the respondent, Jenny Cockrum, appears with counsel Jessica Levitt, and both parties appear together via Zoom video conference.
Counsel, it's the court's understanding that there may be agreements on any material issue in the case, and that we're just here essentially for presentation of testimony to finalize this divorce case. Mr. Vasquez, do you agree with that?
Yes, Your Honor.
Ms. Levitt, do you?
Yes, Judge.
Right, I will need the high points of the settlement that's been reached to be covered in the testimony in this case. Mr. Vasquez, I trust you're going to be calling your client Kevin Cockrum at this time?
Yes, Your Honor.
All right, Mr. Cockrum, if you unmute yourself, raise your right hand, the court will administer an oath to you. You do solemnly swear that the testimony you are about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may question the witness, Mr. Vasquez.
Mr. Cockrum, have you reviewed the proposed journal entry and decree of divorce and marital settlement agreement?
I have.
Do you agree with the terms in that agreement?
I do.
Have you reviewed the parenting plan filed simultaneous with that? That's going to be simultaneous.
I have.
Do you agree with that parenting plan?
Yes.
Have you reviewed the child support worksheet that has also been presented by respondent?
I have.
Do you agree with that?
I do.
Do you believe that the agreement presented to you is fair, just, and equitable?
I do.
No further questions, Your Honor.
Ms. Levitt, do you have questions for Mr. Cockrum?
Judge, not Mr. Cockrum, but I would like to call my own client if the court will allow.
All right, we'll get to that in a moment. Mr. Cockrum, I believe that you've alleged in your petition that you're incompatible with Jenny, and you, those differences are to the extent that you're seeking a final decree of divorce. Are you sure you want to go through with this court granting a decree of divorce at this time with the terms and conditions reached in these agreements?
I am, Your Honor.
Very well. Ms. Levitt, at this time, the court will administer an oath to your client. She'll raise her right hand, please. You do solemnly swear that the testimony you're about to give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may question the witness, Ms. Levitt.
Thank you, Judge. Ms. Cockrum, you are the respondent in 26 DM 1116, correct?
Yes.
Okay, and this matter was filed on March 25th, 2026. Is that accurate?
Yes.
And can you please tell me at what address you and Mr. Cockrum resided at the beginning of this case?
137 South Shea Road in Andover, Kansas, 67002.
Okay, and that's Butler County, correct?
Yes.
Okay. And you have participated in the settlement conversations regarding your case that we are putting on the record here today, correct?
Yes.
Okay. I'd like to ask you first and foremost about the parenting plan. You and Mr. Cockrum share two minor children in common, identified by their initials AC and IC, correct?
Yes.
And you're asking the court to approve a parenting plan in this case that grants the two of you joint legal custody, correct?
Yes.
Okay. And as to an actual parenting time schedule, you and Mr. Cockrum have agreed to and actually have begun exercising a 2-2-3 equal parenting time schedule. Is that correct?
Yes.
Okay. And you alternate where in week 1 you have Monday, Tuesdays, Friday, Saturday, and Sunday, and Mr. Cockrum has Wednesday, Thursdays. Is that correct?
Yes.
And then in week 2, Mr. Cockrum has Monday, Tuesday, Friday, Saturday, Sunday, and you have Wednesday, Thursday, correct?
Yes.
Also set forth in that agreement is provisions regarding how the two of you will communicate and cooperate regarding the needs of the children. Is that correct?
Yes.
Do you believe that those terms are in the children's best interest?
Yes.
And finally, you guys have also reached an agreement to alternate under an even odd year schedule the holidays with the children. Is that accurate?
Yes.
Do you believe that this parenting plan that you've reviewed and will be affixing your signature to here today is in the best interest of the minor children?
Yes.
Okay. Are you asking that the court, upon review and receipt and review of the same, approve it as the order of the court?
Yes.
I'd like to go over the settlement agreement as to the marital debts and assets as well. The parties acknowledge and have stipulated to the validity of their prenuptial agreement. Is that correct?
Yes.
Okay. And as to that prenuptial agreement, The petitioner is to be awarded all assets held in his sole name. Is that correct?
Yes.
Okay, and that includes bank accounts, retirement accounts, and a vehicle, correct?
Yes.
And he is also to be assigned all of the debts in his sole name. Is that accurate?
Yes.
Okay, and that includes any loans or credit cards held under petitioner's name exclusively, correct?
Yes.
And the same can be said of your assets, ma'am. You are being awarded your sole assets, correct?
Yes.
Okay, and that includes your vehicle, a retirement account, and some bank accounts, correct?
Yes.
And you're asking that the court also assign you your individual debts to be those that are held in your sole name, that they be assigned exclusively as your responsibility. Is that correct?
Yes.
As to joint assets, you and Mr. Cockrum own a marital residence together. Is that accurate?
Yes.
And that's the residence you identified at 137 South Shea Road in Andover, Kansas?
Yes.
To further equalize the debts and assets of the parties and to divide the marital property jointly, Mr. Cockrum is to be awarded that marital residence. Is that correct?
Yes.
And he is going to be assigned the mortgage associated with that, correct?
Yes.
And there's an agreement that he will refinance that residence. Is that accurate?
Yes.
Okay. And upon refinancing, you will receive an equalization payment of $74,554.
Yes.
The property that we have disclosed and set forth here today, is that a full and complete recitation of the assets and debts of the parties?
Yes.
Okay. And are you asking that the court accept the division as fully set forth in the journal entry of judgment and decree of divorce as being fair, just, and equitable?
Yes.
And one last question, and I apologize, Judge, I know I'm looking to the left, but I'm looking at our paperwork on my other screen. Are you asking the court to restore you to a prior name here today?
Yes.
Okay, you're currently known as Jenny Victoria Cockrum. What is the prior last name that you're asking to be restored to?
Hernandez.
All right. And then finally, you have reviewed the shared direct expense plan and child support worksheet drafted in this case. Is that is an agreement to share expenses what you and Mr. Cockrum have reached?
Yes.
Okay. And does the shared direct expense plan fully set forth the expenses that the two of you are going to share for the minor children?
Yes.
Okay. And does the child support worksheet accurately reflect your guys' incomes and the cost of health insurance for the minor children?
Yes.
Are you asking the court to adopt that shared direct expense plan and child support worksheet alongside the parenting plan for approval here today?
Yes.
Do you believe that financial arrangement is in the best interest of the minor children?
Yes.
Judge, I have no further questions of my client at this time.
Mr. Vasquez, any further questions for Jenny in this case? Okay, I'm going to take that as a no. You are muted, counsel.
I'm sorry, Your Honor. No, Your Honor. No questions.
Thank you, sir. Court, this time having heard the evidence presented from both parties in the case, finds that the parties are incompatible and that the petitioner shall be granted a final decree of divorce from the respondent. On the legal ground of incompatibility, the marriage of the parties is hereby declared to be dissolved. The court further finds that the parties' agreements regarding child custody, parenting time, and support certainly appear to this court to be consistent with the best interests of those minor children, and the court will approve the parties' agreements and make those the orders of the court as well. The court further finds that upon review of the file and having heard testimony, that the arrangements that have been reached regarding property and debt matters are fair, just, and equitable to both sides. The court will approve the parties' agreements and make those the orders of the court. The court further enters an order restoring the respondent's former name of Hernandez to her. Court will point out that you're not divorced based on this oral pronouncement from the bench, but rather when your decree of divorce is actually submitted to the court approves it and it's filed with the clerk of the district court. It is the filing of your divorce decree, which is the legal act which divorces you under Kansas law. And then for a period of 30 days thereafter, neither one of you should try to remarry. Any marriage you would attempt to enter into during that period would be voidable under Kansas law. So just wait 30 days past your decree's filing date before you attempt to enter into a new marital relationship. Obviously, the agreements that you've reached on a parenting plan means that you work together for the best interests of your kids to this point. I hope that you can always work together for the benefit of your children and that your children will see you getting along when it comes to them and not seeing any conflict. Good luck in that regard. All right, counsel, how long will it be before this decree is actually finalized, fully circulated, and submitted to the court?
Judge, I realized that the draft I sent to council today did not include the language restoring my client's last name, so I need to resend that to him here when we hang up on this Zoom. From there, my client is ready and prepared to sign, and so I expect within the next day or two, they will be uploaded. Unless Mr. Vasquez feels differently, certainly he should interrupt me. I also want to put on the court's radar that when we submit that, we will submit with their companion case, the 26 DM 102 PFAA journal entry of dismissal, so that the parenting plan can be properly effectuated.
Very well. Thank you for that announcement. That should conclude both Cockrum matters which are currently pending in the district court at this time. Good luck to both of you in the future. If there's nothing further, then the Cockrum matters will be in recess at this time, and this meeting may be ended for all.
Thank you, Judge.